There's no more running.
Right.
You can't dip off to Florida and send me a message saying, hey, I'm in Florida, catch me if you can. So Mr. Bowman, remember, this is different. If you run, you go to jail. If you confess, you get services.
Yes.
Got it?
Yes.
And don't send me messages on Facebook, okay?
Yes, yeah. Thank you guys.
Is in the matter of people of the state of Michigan versus Gary Scott Bowman. I have two files. I have 23-21342FH and 23-21445FH. Mr. Bowerman is represented by Matthew Murphy. And Mr. Murphy, you've had an ample time to speak with Mr. Bowerman.
Yes, Your Honor.
All right, Mr. Bowerman, have you had an opportunity to read and review the pre-sentence report?
Yes, Your Honor.
Okay. Have you had an opportunity to discuss the pre-sentence report with Mr. Murphy?
Yes, Your Honor, I have.
All right. Are you satisfied with your attorney and the advice that he's given you?
Yes, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
On file number 23-21342FH, the probation department has calculated the minimum sentencing guidelines to be 0 to 11 months on the motor vehicle unlawful use. And on the police officer assaulting, resisting, obstructing, attempted, they calculated the guidelines to be 0 to 17 months. Mr. Murphy, do you agree with the calculation of guidelines?
Yes, Your Honor.
All right. Mr. Bowerman has 26 prior misdemeanors and 7 prior felonies. So before the court passes sentence, is there anything you'd like to say on behalf of Mr. Bowerman?
Yes, Your Honor. From our understanding, the recommendation is for Mr. Bowerman to go into the drug court there. I would ask the courts, obviously, to follow that recommendation. Mr. Bowerman wants to take advantage of the opportunity and participate in that court. I would ask the courts, in regards to the one file, there was a recommendation for 6 months in jail with credit for, I believe, 152 days served, if I'm not mistaken on that. I would ask the court to consider, I'm not sure how much time Mr. Bowerman would have left to serve that out. I would just ask the court to consider giving him credit for time served on that file and closing that out. I just want him to get processed and into rehab as fast as possible. Again, I don't see the point in him staying any longer at the jail. I don't know if he would or not, but that's just what I was asking the court to consider. Other than that, we would ask the court to adopt the recommendation.
All right, Mr. Bowerman, is there anything you'd like to say on your own behalf?
Yes, Your Honor, I just emphasize on what Mr. Murphy had said. And
Mr. Bowerman, I'm sorry, that room has really bad audio. So if you can like lean forward a little bit and say it again for me, please.
yes, Your Honor, I'd just like to emphasize on what Mr. Murphy had said, and I am just eager to take the opportunity to complete recovery court, and I'm excited about giving this opportunity and chance again to get the opportunity to do that. And I'd love to go to rehab as soon as possible. And I've never been there before in all my past. So I think that's what would be best for me, and that's what I need, and that's what I want to do. If you please follow the recommendation, I really appreciate Ms. Angelo.
All right. So, Mr. Bowerman, was it you or your brother that sent me a Facebook Messenger a couple years from Florida?
That was me, Your Honor.
Okay. All right. So, Mr. Bowerman, I've known you since you were like 18. I think I represented you the first time you got in trouble. How old are you now?
40, Your Honor.
Okay. So you're getting old now. Are you getting tired of this?
Yes, Your Honor, definitely am.
So drug court is an amazing program. And I will tell you that having a lot of experience representing people who have addiction issues, when people come into the drug court, there are people that I think, oh my God, they're never going to make it. There are people that I think they have all the skills necessary to make it and don't. And then there are people who just quietly keep their head down, do what they need to do, and move on with their lives. So I know that you're smart enough to do it, but you have to fully be willing to dedicate yourself to it, and it works. It
Yes.
absolutely works. And you can't run. There's no more running.
Right.
You can't dip off to Florida and send me a message saying, hey, I'm in Florida, catch me if you can. No more of that. So
No,
when
I will not do that, I promise.
okay. And if you relapse, you go to Miss Teskey and say, hey, I relapsed. And then we give you services. Because it's not about locking you up. It's about giving you wraparound services and all the help that you need to succeed.
Right, Your Honor.
Okay.
I've been taking the engagement group in here too, and also talking to a lot of people inside of here, and I know a few people on the outside, like you said. So I've done a lot of research about it, and I know what the program's about, and I believe that it's a great program. I'm glad that it exists, and I'm really hoping I get the opportunity to prove to you and myself that I can do this. And you're definitely right about everything you said.
Yeah, I know you can do it. You got to get to the point you know you can do it. All right.
Yes, Your Honor.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, indication for the law and the protection of society. Sentence of the court on file number 23-21342FH, that you will serve 6 months in Lenawee County Jail. Will give you credit for 152 days. So I think you pretty much already have good time and credit for time served on that. And there is nope. All right. And then on file number 23-21445FH, it's a sentence of the court that be placed on probation for a period of 3 years. Mr. Bowman, during that term of probation, you cannot use marijuana. You can't use medical marijuana. So because it's a drug court program, you can't use or possess any alcohol or other intoxicants. You must comply with all the requirements of alcohol testing and drug testing from the probation department. You must take all medication as prescribed by a licensed physician. You must participate. Do you have your GED?
No, Your Honor. It's something that I am going to obtain during this process, and I've been
okay.
wanting
So what
to
I
do
would
it,
say,
just haven't done it yet. Yes,
okay. It's not something I'm going to want you to do right away because you're going to have other things to focus on. But in the last half of the 3 years or something, you can work on that.
okay.
You must complete a psychological evaluation if referred. You must complete mental health, domestic violence, battery intervention, or any other treatments if ordered to by your service providers. You must not have any contact with an Isaac Ben scooter, either directly or through another person. You can't be within 500 feet of the residence, school, or place of employment. The field agent has the right to enter your home at any time for probation supervision. And you must submit to search of your person and property, including but not limited to your vehicle, residence, computer, without warrant if they have reason to believe you have something that violates your term of probation. All right, it's a sentence of the court. You'll serve 1 year in the Lenawee County Jail, give credit for 152 days. As soon as a bed becomes available, you'll be released to that treatment program. It's the holidays, so it might be a week or two. So understand. And then when you go to that program, you must obey and comply with all the requirements of that program and not leave or get kicked out. Okay. On 23-21342FH, the crime victim rights fee will be $75 and the state cost will be $50. And then on file number 23-21445, you will pay $750 in court costs, a crime victim assessment fee in the amount of $130. And there is a $68 state cost. Attorney fees in the amount of $450. There's a $30 per month supervision fee without tether, but if we have to put a tether on you, then it's $60 per month. And you must attend and complete the Lenawee County Adult Recovery Court following all the recommendations made by the same. So Mr. Bauer, remember, this is different. If you run, you go to jail. If you confess, you get services.
Yes.
Got it?
Yes, Your Honor.
Okay. So we're going to send over to the jail 3 copies of your notice of right to appellate review for each file. I need you to initial and date the top copy for each of the files just to acknowledge you received the paperwork. That's going to go on my file. The other copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Yes, sir.
And don't send me messages on Facebook, okay?
Yes, sir. Thank you guys all.
All right.
Have a great day and happy holidays.
Thank you, Mr.
All right, you
Bowman.
too. Thank you, Mr. Bowerman.
Thank you.
This reflects a well-known principle in behavioral psychology: conditional trust. Systems offer support only while compliance is proven. The choice feels safe because it sounds cooperative. But legally, it's dangerous because drug court removes distance between mistake and punishment. There's no buffer, no sovereign-style argument about jurisdiction or traveling versus driving. One violation converts treatment into custody immediately. This case shows how the court draws a hard line between accountability and chaos. Drug court isn't leniency, it's leverage. The moment probation is tied to treatment, the defendant gives up protections most people rely on: warrantless searches, zero-tolerance rules, immediate jail exposure. That's the trade. People influenced by sovereign citizen thinking often believe intent overrides structure, that saying the right words, invoking status, or rejecting jurisdiction changes outcomes. Here the court makes the opposite clear. Outcomes are driven by behavior, not declarations. You don't negotiate with the system after entry, you perform inside it. The warning about running isn't rhetorical. Flight converts every future explanation into evidence of risk. Confession, by contrast, preserves credibility. That's why the judge repeats it. Credibility is the real currency here. Lose that, and the program stops working for you. This is also why past patterns matter. Extensive prior history doesn't just increase punishment, it shrinks patience. Each additional condition isn't about control. It's about predicting failure points before they happen. The court is managing probability, not personality. Nothing dramatic has to occur for consequences to arrive. Missing a test, leaving a program early, testing boundaries. Drug court treats those as decisions, not accidents, and decisions compound. At this stage, freedom exists only as long as structure is respected. Not believed in, not argued about, respected. And from here forward, every small choice quietly answers one question: services or jail?